Assembly of Nyamira, I wish to introduce the councils representing the County Assembly of Nyamira. We have Senior Counsel Kato Akigen. We have Counsel Mokua Ndubi, assisted by myself. My name is Doris Ngeno. We are looking forward for a constructive and productive engagement. Thank you, Mr. Speaker, sir.
I now similarly invite Counsel for Governor to introduce the legal team representing the Governor by stating the full names and designation of each person. You may proceed.
Thank you, Mr. Speaker, sir, and good morning to distinguished senators. My name is Elias Mutuma. Mr. Speaker, sir, I wish to confirm that pursuant to the notice to appear, the Governor is before the Senate in person and is also represented by the following council, led by myself, Elias Mutuma, accompanied by my learned friend, Zelma Bonuke, Ombui Ratemo, Branley Morethi. Those are advocates. Then we have Sylvia Njoki, our legal assistant, and Michelle Makandi, our legal assistant. And then we also have Erastus Orina, who is the county attorney of Nyamira County, appearing in that capacity. Thank you, Mr. Speaker, sir.
Senator Fakitui, kindly take your seat. Now, honorable senators, ladies and gentlemen, on behalf of the Senate, I welcome the team for the County Assembly, the team for the Governor, members of the public and the media to the Senate and to these proceedings. Finally, I now invite the clerk to call the next order and thereafter to read the charges against Honorable Amos Kimomi Nyaribo, the Governor of Nyamira County. I thank you.
Order number 2, reading of the charges on the proposed removal from office by impeachment of Honorable Amos Kimomi Nyaribo, Governor of Nyamira County. The Honorable Amos Kimomi Nyaribo, the Governor of Nyamira County, please take the stand. Honorable Amos Kimomi Nyaribo, the Governor of Nyamira County, the charges against you as received from the County Assembly of Nyamira are as follows, and I quote: Ground 1, gross violation of the Constitution and other laws. The particulars of this ground are as follows. Allegation 1, gross violation of the Constitution 2010 and the County Government Act 2012 through deliberate formal engagement, endorsement and support of unlawful, illegal and unconstitutional bunge mashinani. Whereas Article 1, 10 and 73 of the Constitution 2010 enshrine the principles of sovereignty of the people, the rule of law and the responsibility of state officers, whereas Article 176(1) of the Constitution of Kenya 2010 unequivocally establishes a county assembly of each county, and Section 7B(2) and 14(1)(a) of the County Government Act 2012 govern the lawful sittings and procedure of the County Assembly, whereas Section 6A(1) and the third schedule of the County Governments Act 2012 specifies the location of Nyamira County Government as Nyamira Urban Area, whereas Section 7B(2) of the County Governments Act 2012 provides that except for a sitting of a new County Assembly, under subsection 1, a sitting of a County Assembly may be held at any place within the county and may commence at any time as the County Assembly may appoint. Whereas Section 32, subsection A of the County Governments Act 2012 requires the Governor to diligently execute the functions and exercise the authority provided in the Constitution and the legislation, Whereas Section 30, subsection 3C of the County Governments Act 2012 requires the governor to promote democracy, good governance, unity and cohesion within the county. 1. His Excellency Amos Kimomi Nyaribo deliberately engaged, endorsed, and supported unlawful, illegal, and unconstitutional bunge mashinani gazetted by Enoch Ogori Okero via Kenya Gazette Notice number 14229 of 2024, dated the 29th of October 2024, and the appointment of an acting clerk via Kenya Gazette Notice number 14230 of 2024, despite knowledge of the fact that the said Enoch Ogori Okero had been removed from the office of the Speaker by way of an impeachment as published in the Kenya Gazette number 14050 of 2024, dated 25th October 2024. 2. The Senate of the Republic of Kenya on 15th May 2025, while considering a progress report of the Standing Committee on Devolution and Intergovernmental Relations on the operation and leadership crisis affecting the County Assembly of Nyamira, resolved that the decision and resolutions made by the impeached Speaker and members of the County Assembly that convened outside the gazetted precincts of the County Assembly are null and void. The same was communicated to the Clerk of the County Assembly of Nyamira and copied to the Governor of Nyamira County via the letter reference SEN/RESOLS/17/2025, dated 22nd May 2025. 3. The impeachment of Enoch Ogori Okero was affirmed by the judgment of the High Court at Bomet in petition number E004 of 2025, delivered on the 4th day of June 2025. In paragraph 74 of the said judgment, it was the court's finding that the 7th respondent, Enoch Ogori Okero, the impeached Speaker, ceased to hold office on the 24th of October 2024. 4. Further, in paragraph 85 of the same judgment, the court found that any actions or duties performed by the 7th respondent, Enoch Ogori Okero, the impeached Speaker, were illegal, null, and void, as the 7th respondent either had the power nor the locus to do so. Whereas the governor and his accomplices maintained there were court orders stopping the County Assembly from removing Enoch Okero from the office of the Speaker. 5. The High Court at Bomet, via the judgment in petition number E004 of 2025, delivered on the 4th day of June 2025, settled this matter and held that there was no such order and that the County Assembly was not barred from impeaching Enoch Ogori Okero from office of the Speaker or exercising its constitutional mandate. The same is found in paragraph 72 of the said judgment, where the court held that, I quote, this court's critical interpretation of order number 2 issued on 11th October 2024 by Okwani J was that she issued conservatory orders staying the suspension of the 7th respondent as Speaker. This effectively meant that 7th respondent resumed his duties as Speaker of the County Assembly. In regards to order number 3, the judge issued conservatory orders that barred interference of the duties of the 7th respondent as Speaker. Order 3, as worded above, did not mention that the County Assembly of Nyamira was barred from impeaching 7th respondent or exercising its constitutional mandate. 6. His Excellency Governor Amos Kimomi Nyaribo consistently and deliberately supported and engaged with gatherings of unlawful, illegal, and unconstitutional bunge mashinani, which conducted its meetings from October 31st, 2024 up to June 2025 in locations away from the lawful and official gazetted premises of County Assembly and without lawful appointment. 7. Further, the governor made public pronouncements declaring Enoch Ogori Okero and Silvanus Ndemo Nyamora as the legitimate speaker and clerk respectively, while aware that Enoch Ogori Okero was duly impeached. 8. The governor's actions to formally engage, endorse, and support unlawful, illegal, and unconstitutional bunge mashinani directly undermined the legislative representation and oversight role of the County Assembly of Nyamira as established by the Constitution of Kenya 2010 and County Governments Act 2012, thereby constituting a gross violation of the rule of law and the principle of separation of powers. Allegation 2, gross violation of the Constitution of Kenya 2010 and the County Government Act 2012 and the Public Finance Management Act 2012 by assenting to the Nyamira County Supplementary Appropriation Bill 2024 without the approval of the County Assembly of Nyamira. Whereas Article 175A of the Constitution of Kenya 2010 requires that the county government shall be based on the democratic principles and separation of powers, whereas Article 185(1) of the Constitution of Kenya 2010 states that the legislative authority of a county is vested in and exercised by its county assembly, whereas Article 224 of the Constitution of Kenya 2010 states that on the basis of the Division of Revenue Bill passed by Parliament under Article 218, each county government shall prepare and adopt its own annual budget and appropriation bill in the form and according to the procedure prescribed in an Act of Parliament, whereas Section 21, subsection 1 of the County Governments Act 2012 requires that the County Assembly shall exercise its legislative power through bills passed by the County Assembly and assented to by the Governor, whereas Section 130 of the Public Finance Management Act 2012 provides for the procedures of processing a county budget, including transmission from the county executive to the county assembly for consideration and approval. 1. The governor on 26 November 2024 assented to the Nyamira County Supplementary Appropriation Bill 2024 without the approval of the County Assembly of Nyamira, in total defiance to the constitutional principle of separation of powers. 2. The Nyamira County Supplementary Appropriation Bill 2024 is not among the business transacted during the morning and afternoon sittings of the County Assembly of Nyamira on 26 November 2024. 3. The Nyamira County Supplementary Appropriation Act 2024, as assented by the Governor, significantly altered the priorities and development programs in the original approved budget. 4. This conduct constitutes a gross violation of Articles 175A, 181(1), and 224 of the Constitution of Kenya 2010, Section 130 of the Public Finance Management Act 2012, Section 21(1) of the County Governments Act 2012, and Order Number 137(1) of the County Assembly of Nyamira Standing Orders, and the due process of the law, which requires that the county budget be approved by the County Assembly. 5. The same undermined the representation and oversight role of the County Assembly. The supplementary budget was assented to, devoid of participation of the people and or their representatives. Allegation number 3. Gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 by appointing Dr. Peris Nyaboke Oroko, alias Peris Mongare, to the County Executive Committee CEC without the approval of the County Assembly. Whereas Article 179(2)(b) of the Constitution of Kenya 2010 provides that the County Executive Committee shall consist of members appointed by the County Governor with the approval of the County Assembly from among persons who are not members of the County Assembly. Whereas Article 259 of the Constitution emphasizes the interpretation of the Constitution, which includes the respect for judicial announcements. Further, whereas Section 30D of the County Governments Act 2012 requires the governor to appoint, with approval of the County Assembly, members of the County Executive Committee. Whereas Section 4 of the Public Appointments County Assemblies Approval Act 2017 requires that an appointment under the Constitution or any other law for which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act. 1. His Excellency Amos Kimomi Nyaribo appointed Dr. Perez Nyamboke Oroko to the County Executive Committee without the approval of the County Assembly of Nyamira, in total disregard of the due process of the law. 2. In response to an inquiry by the County Assembly, the County Executive Committee member for Public Service Management maintained that the Perez Nyamboke Oroko is duly appointed. 3. Failure to submit the name of Perez Nyamboke Oroko for vetting and approval by the County Assembly of Nyamira constitutes gross violation of Articles 179(2)(b) and 259 of the Constitution of Kenya 2010 and Section 30D of the County Government Act 2012. 4. The governor has to date proceeded to retain Dr. Perez Nyamboke Oroko and supervised her integration into the payroll system since June 21, 2025, and authorized the payment of her salary and allowances despite clear judicial and senatorial pronouncements declaring all actions of Bunge Mashinani as illegal, null, and void. 5. The governor willfully circumvented the legitimate constitutional approval process, rendering the appointment unlawful. 6. This action presently bypassed the County Assembly, constituting a gross violation of the Constitution and statutory provisions governing appointments. Allegation number 4. Gross violation of the Constitution of Kenya 2010, the Urban Areas and Cities Act 2011, and Public Appointments